Having spent the better part of 20 years assisting tens of thousands of companies through the organization and startup process, I have had the unique opportunity of participating in, managing, and observing a unique laboratory of entrepreneurism in action. Some of these companies are recognizable names and have gone on to attain significant success and profitability. Others, however, never survived managing the first real crisis that crossed its path. It seemed as though they were engineered for failure. Those failed companies have almost all followed a fairly narrowly defined set of principles that caused their ultimate collapse. The principles of entrepreneurial business failure are the topic of this video and playlist. You can get information on how to succeed in business almost anywhere. Still, this video clearly outlines one of the simple, basic things that any small business owner or entrepreneur can do to make such a perfect mess of their business that is virtually guaranteed for ultimate failure. In fact, it is possible to implement these strategies so completely that a business that appears to be financially successful, even for many years, is nevertheless assured of complete destruction. The bad news is that too few entrepreneurs really know how to identify these fail-proof landmines to business failure and are left to stumble upon them unknowingly. Never fear, trusting viewer, for this video will educate and empower you to call upon these principles whenever you choose, thus providing you with means to avoid the odds of wrecking your business accidentally and instead allowing you to do it on purpose. Or, I suppose you could also use this book to help you avoid them entirely, making your business more likely to succeed. That is, if you are into that sort of thing. Good luck! Please like this video and subscribe to this channel for more of this content. Make sure you have seen the video on stupid thing number 1. There is a reason it is number 1. Now on with the video, stupid thing. Number 2, to be blissfully unaware of risks. This is a big one. First-time entrepreneurs are very prone to this mistake. However, they are not alone. Even experienced businessmen and women can forget. The world of business is an extremely dangerous place, and real monsters are around every corner, and the monsters will eat you if they get a chance. The purpose of this video is to help you see where the monsters might be hiding. A culture of lawsuits. An international law firm discovered an interesting fact in a 2006 study. The average company in the United States juggles 37 lawsuits at any given time. 37 lawsuits at once! Not all of those lawsuits find the company on the defensive end of the legal world. The study showed that half of all companies had also filed a lawsuit against someone during the previous year as well. What's worse, the scary part of that picture isn't fully realized until you understand that, according to the study, in almost half of the cases, the corporate counsel could not predict, control, or budget for the cost of litigation. A company in that position can easily bleed to death from multiple wounds disguised as legal fees. Even today, after tremendous efforts have been made in tort reform in our country to control rampant litigation and out-of-control jury awards, litigation is so ingrained in our culture that it is difficult to imagine the day that our current litigation culture ceases to exist. In fact, as technology increases and the development of our society actually speeds up, the smart money is on the premise that litigation will actually increase in coming years. It will probably get even worse. Consider the fact that the typical personal injury claim in the United States averages almost a full year. Or think about how you rely on technology to communicate with others in your personal and business life, and then stop to recognize that electronic discovery is the top new litigation burden in our culture. How comfortable would you be with having to disclose all of the emails you have sent or received over the past couple of years under court order? There are over 1.1 million licensed practicing attorneys in the US. That is one for every 300 men, women, and children in the country. How do they pay their bills? The answer is often that they have to generate their own demand by generating lawsuits. Watch daytime television for an hour and you are almost guaranteed to see ads run by attorneys to recruit people to file lawsuits. Class action lawsuits have developed into their own cottage industry within the legal community, where the only winners are the attorneys. Recently, I was sent a letter from a law firm that had filed a class action lawsuit against the insurance company that carries my homeowner's policy. Evidently, I was part of the class of people that the insurance company had damaged, and the letter was sent to notify me of the settlement of the lawsuit. What did I get? A coupon! What did the lawyers who handled the lawsuit get? Over $500,000 in legal fees. Who does that system really protect? As an entrepreneur, you need to understand the magnitude of the litigation culture that is working against you. And when you understand that, you can begin to prepare yourself to do business in that environment in a manner that protects you and your family. Contract liability. In business, you simply cannot operate without making a number of agreements with others. These agreements may involve business partners, investors, employees, agents, independent contractors, vendors, competitors, customers, or clients. They can include both formal written contracts open to interpretation of facts and language and informal unwritten agreements open to interpretation of the very presence of the agreement. Sometimes these agreements are notarized and documented. Other times, they are consummated on a handshake and a pat on the shoulder. In either case, welcome to the complex world of contract litigation, the one lawsuit risk for business in America. I don't know anyone who has not had the experience of dealing with someone who failed to uphold his or her end of an agreement. It happens all the time. However, in business, that experience can be very costly. Frequently, the only recourse for damages is in the courts. Product liability. If your business includes manufacturing, shipment, handling, processing, or sales of tangible products, you need to be aware of the risks associated with product liability. Generally, product liability can exist as the result of three separate kinds of failure. 1. Manufacturing defects. Traditionally, manufacturing defects have resulted from shoddy workmanship, worn tooling, or inadequate or improper components. As I write this, current events are filled with news of outsourced toy manufacturing taking place in China, where lead-based materials have been used in the manufacturing process. As our manufacturing economy continues to transition overseas, where the regulatory environment is not as stringent, we will see more American companies brought into product liability lawsuits resulting from the actions of their suppliers. 2. Design defects. Liability results from products that have inherent design flaws. The liability can be enormous when a product's design causes injury or damage. The poster child for design defects has to be the infamous Ford Pinto. To fight competition from Volkswagen and Toyota, Ford rushed the Pinto into production in 25 months, when their standard production schedule required 43 months. The design specs for the Pinto required that the car weigh less than 2,000 pounds and cost under $2,000. Before production began, engineers discovered a major flaw in the design. The gas tank ruptured in rear-end collisions. Because the assembly line was already ready for production, Ford decided to manufacture the car anyway, even though the fix was later proven to only add $508 to the cost of the car. Over 2 million Ford Pintos were sold. As a result, over 500 people burned to death in auto accidents, according to a 1977 expose written by Mother Jones magazine. 3. Failure to warn. Even if a product is properly designed and manufactured, lawsuits can still result if the public is not properly warned about the risks associated with using it. Sometimes the warnings make sense, such as, warning: this product is processed using machinery that also processes peanuts. If I am allergic to peanuts, I am grateful for that warning. However, the risk of failure to warn is so great that our culture has created a lot of purely ridiculous warning labels. For external use only, on a curling iron. Do not use in shower, on a hairdryer. Recycled flush water unsafe for drinking, on a toilet at a public sports facility in Ann Arbor, Michigan. This product is not intended for use as a dental drill, on an electric rotary tool, not intended for highway use, on a 13-inch wheel of a wheelbarrow, not dishwasher safe, on a remote control for a TV. Do not put any person in this washer, on a washing machine in a laundromat. Never use a lit match or open flame to check fuel level, on a personal watercraft. This textbook asserts that gravity exists. Gravity is a theory, not a fact, regarding a force that cannot be directly seen. This material should be approached with an open mind, studied carefully and critically considered, on a textbook at Swarthmore College. Seriously, as silly as those warnings sound, they serve to illustrate the degree to which businesses are reacting to the risk of being held liable for failure to warn. You just have to know that every warning label would never exist unless an attorney was involved somewhere in the process. If a judgment results from a product liability lawsuit, it can get very expensive really quickly. Juries can award compensatory damages, loss of consortium damages, damages to a spouse even if not directly injured, and punitive damages. Employee liability. The transition from being a one-man show to having employees is fraught with challenges and danger. The employer has to follow complex rules and maintain all kinds of documentation covering everything from how long job application resumes can be maintained to detailed files on employee performance, particularly when correction occurs, payroll records, hiring records, etc. Employers may find themselves exposed to legal actions brought by the Equal Employment Opportunity Commission, EEOC, if accusations are made that the employer has violated anti-discrimination laws. These actions may be legitimate, or they may be fabricated. My company recently received a job application from a man who would have been considered among a discriminated class. His resume was glowing. He appeared to be an all-star in his field. The problem was that they were completely fake when we checked his education, work history, and references. So naturally, we didn't bring him in for an interview. A few weeks later, we were served with an EEOC discrimination lawsuit for not hiring him. It was a complete setup. Naturally, we prevailed. All it took was a little time that we will never get back and money that we can't spend on something productive. Employees expose the employer to other liabilities as well. The employer might be responsible for harm caused by employees to others. Legal theories have allowed courts to hold employers liable for injuries their employees inflicted on coworkers, customers, and total strangers. For example, Domino's Pizza pulled its 30 minutes or its free delivery promise after a 1993 case that led to an award of $750,000 in actual damages and $78 million in punitive damages against the pizza company after a delivery driver ran a red light and struck a vehicle. A company that issues cell phones to its employees so they can check in at the office while on the road was found to be liable when the employee hit a pedestrian while talking on the cell phone. A car rental company hired a man who later raped a coworker. If the company had verified his resume, they would have discovered that he had actually been in prison for robbery during the years he claimed to be in school. The company was found liable to the coworker. Intellectual property claims. Entrepreneurs generally don't recognize the enormous liability that can come from intellectual property claims. Of all business risks, this category will most likely result in a judgment above $500,000. Intellectual property rights cover many grounds, including patents, trademarks, trade names, branding, copyrights, trade secrets, web domain names, industrial design rights, etc. Intellectual property can be vital to a company's business model. In fact, the existence of defensible intellectual property is often the basis for investors and venture capitalists to make an investment into a company to take it to the next level. The typical entrepreneur moves rapidly when he/she has an idea they want to get to market. Usually, little time or attention is given to researching trademarks, patents, and web domains. As a result, it is not unusual for a company to find itself on either end of an intellectual property lawsuit. An eager entrepreneur can easily and innocently violate the intellectual property rights of someone else in their rush to get their business going. Conversely, an entrepreneur who depends on protecting their intellectual property rights as their market differentiator may be forced to defend their rights if a competitor starts to infringe on their rights. Between 1996 and 1999, the number of patent applications at the U.S. Patent and Trademark Office grew by over 30% per year. The number of patents granted has grown to the point that the number of patents issued has exceeded 6.2 million, with over 1 million active and enforceable patents enforced today. Each one of these patents represents a paper landmine in today's business world. Not surprisingly, in the decade since 1996, patent infringement lawsuits have increased 100%. Statistically, each one of those patents has a 1% chance of being litigated, although patents in the area of technology or pharmaceuticals can exceed a 25% chance of litigation. According to the Wall Street Journal, an intellectual property dispute can put an entrepreneur in a difficult predicament. For example, patent infringement cases that are considered to be relatively small, involving damages between $1 million and $10 million. Small is relative, I suppose. Average $748,000 in litigation costs. Trademark and copyright litigation is not quite as expensive, but it still averages around $249,000 and $180,000, respectively. With high litigation costs, even the winners are usually left with settlements that barely cover their expenses. The issues related to intellectual property claims are so complex that even the largest companies in the world, with seemingly unlimited legal resources at their disposal, find themselves caught in the muck of a legal lawsuit. Here are some recent examples. Procter & Gamble filed a lawsuit against Kraft Foods over the shape and design of its updated coffee cans. Microsoft and Lucent Technologies have been suing since 2002 over alleged infringements of a Lucent patent. Microsoft's counterclaim alleges that Lucent also infringes on several Microsoft patents. Technology company Solomon Technologies sued Toyota over patent infringement in its use of proprietary technology in Toyota's hybrid vehicles, which, if successful, could prohibit Toyota from importing the popular vehicles into the U.S. SCO Group, formerly known as Caldera Systems, has a $5 billion lawsuit against IBM, accusing the giant company of devaluing its version of the Unix operating system by contributing SEO's intellectual property to the codebase of the open-source operating system known as Linux. Amazon.com has filed a suit against several online retailers for infringing on their patent for a one-click checkout system. Amazon was, in turn, sued by IBM, which claimed that the patents that Amazon was defending actually belonged to IBM. As expensive as these lawsuits are to fight, imagine how much it costs if you lose one of these. In today's world, it is just crazy to go into business without knowing that these landmines exist, and without planning to protect yourself from the potential damage up front. For innovative entrepreneurs, every new idea is fraught with potential multi-million-dollar risk. One of the sad realities of doing business in this culture is the fact that lawsuits and litigation are probably in your future. It isn't a matter of if, it is simply a matter of when. And when your when rolls around, won't you feel much better knowing you structured, planned, and attended to the details of your business in a way that gives you the best personal protection available? Of course you will. You can thank me later. If this content was worthwhile to you, please take a moment to like and subscribe to our channel. One small step by you is a giant leap for our channel. Thanks, and look for our video on the number 3. Stupid thing that entrepreneurs do to ruin a perfectly good business: not using a business entity.